morning. May it please the court, Brian Williamson on behalf of the United States. The district court did not procedurally err and did not abuse its discretion with regards to the substantive reasonableness of defendant's 240-month above guidelines sentence. The district court started with defendant's proposed guidelines range and then went above those guidelines range upon a thorough explanation of the 3553A factors. As such, the primary basis for the above guidelines sentence was the court's finding that the offense conduct was horrible, horrific, and deserving of very, very serious consequences for Mr. Kelly. I think the court has already picked up on that. Defense counsel loses the forest for the trees a little bit in arguing that the above guidelines sentence was based solely and exclusively on the obstructive conduct. And Is it your view, Mr. Williamson, that the court did rely on the obstruction of justice conduct in imposing sentence? The starting point was adopting defendant's guidelines range. But is it a basis to vary? I think it was a data point in justifying the above guidelines sentence. It was not, neither were imposed specifically as a mechanical basis to vary above. And can you distinguish for me between what you mean by a data point and a basis to vary? Right, Your Honor. Did the court consider it? It's hard to tell from the court's comment that it could consider, and I'm not sure there's any specific finding by a preponderance of the evidence as to why the obstruction of justice conduct occurred, or that the government did prove it by a preponderance of the evidence. Yes, Your Honor. So, the sentencing court found by a preponderance of evidence that obstructive conduct occurred. Now, whether that comprised a specific part of the above guidelines sentence, or whether that, it's clear that on the offense conduct alone, the 3553A factors alone, and the seriousness of the conduct, the court could have arrived at the 240-month above guidelines sentence by itself. So just to pin this down with clarity, your position is that Judge Lynam-Weber made the findings necessary to consider the obstructive conduct? Yes, Your Honor. Okay.
This is what a good lawyer sounds like. Crisp, legally sound arguments, so effectively delivered, so precise. He only had to use 8 minutes and 56 seconds of his time, left 1 minute and 4 seconds on the clock.
Turning to the statute of limitations question, defendant's indictment for sexual exploitation and inducement of children was timely brought. The statute of limitations period as to defendant's victims never expired, and at the time of the offense conduct, prosecutions were viable until the victims turned 25. But before Jane, Nia, or Pauline reached the age of 25, Congress in 2003 expanded the statute of limitations period to the life of the child. This was unambiguous. Section 3283 states that no statute of limitations that would otherwise preclude prosecution for an offense involving sexual exploitation of a child shall preclude such prosecution during the life of the child. This is a universal approach to changing the statute of limitations. It's forward-leaning and it's backward-leaning. There is and can be no ex post facto violation when an otherwise viable statute of limitations period, such as we have here, is expanded. Multiple courts of appeal agree on that front. And while this court has yet to have occasion to review that specific question with regards to that specific statute, 18 U.S.C. 3283, it is nonetheless agreed with the principle that no constitutional violation occurs in these circumstances. That's the United States v. Gibson case, relying on Supreme Court precedent in Stogner. The application of 18 U.S.C. 3283 should thus not be considered impermissibly retroactive. It is not reviving a previously moribund limitations period. Instead, it is explicitly precluding the application of prior limitations periods that were anything less than for the life of the child. The indictment in this case— Are you saying that the land graph analysis doesn't matter given Gibson? I wouldn't set aside— Because it seems like it's a separate issue. The Gibson is the ex post facto argument, and defendant has conceded that's not what he's pursuing on appeal. Instead, he's arguing the statutory construction, that if you look at Congress's intent and look at the framework under land graph, that
Congress's intent was not to make this retroactive, which is a separate issue.
Your Honor, I think the language of the statute speaks unambiguously, and we don't even have to get to what the underlying intent of Congress was. It's hard to read 3283 in a manner that doesn't apply both backwards and forwards. If we do apply Landgraf, it satisfies both the first step and the second step.
Defendant spent a lot of time in the brief focusing on the 2C case and the statements that statute of limitations should be liberally interpreted in favor of repose in criminal cases in particular. Can you respond to that argument, please?
Yes, Your Honor, absolutely. So the 2C case and its progeny, that's a fine statement of what 2C stands for, but there's always a carve out for when Congress explicitly provides for otherwise. And it's the government's position that that's exactly what 18 U.S.C. 3283 does.
What if we get to step 2 of Landgraf? How would 2C impact that analysis?
So, in a sense, defense is asking for a kind of an exception that doesn't exist with that. Reading repose into the second step of 2C, in defense's brief, they set out that this creates, there's a broader set of rights and obligations in that than are provided specifically in the second step of Landgraf. I wouldn't say we need to reach the second step of Landgraf because step 1 is satisfied given the unambiguous nature of the statute. And as to step 2, step 2, if there is no retroactivity problem, we're not even in step 2 of Landgraf. And I'm not sure they've pointed to a case that says that the repose considerations in 2C supersede the satisfaction of steps 1 and 2 of Landgraf. So if the court doesn't have any further questions.
I don't think any circuit has sided with your position.
You're right. Yeah, that's correct. But
I don't think any circuit has sided with your
you're right.
position.
Yeah, that's correct. But
I don't think any circuit has sided with your
you're right.
position.
Yeah, that's correct. But